Okay, we're just about a minute past the hour, so we'll go ahead and get going. We've got a lot of content to get to today. First, let me say good afternoon, and thank you all so much for taking time out of your day to join us for our presentation on Chicago's predictive scheduling law, titled Chicago's Predictive Scheduling Law in an Unpredictable Time. We're really excited to present this topic to you today. As most folks here know, or hopefully I'm not telling you for the first time, this new law is set to take effect in Chicago on July 1st. So we're just on the cusp of this new law's effective date. And certainly that's going to feel tough to a lot of employers at a time when many employers are struggling to survive and to get folks back to work and to make payroll. This new law, one that, like other predictive scheduling or fair work week laws before it, would require or will require employers to pay premiums to employees even for times that they don't work due to last-minute schedule changes and things of that nature, has the propensity to feel daunting and impactful and stress-inducing for employers who are covered by the law. So we're here to help, and hopefully we can do that in the time that we've got today. With that, let's go to the next slide. Okay, so we certainly want to get to the content. Like I mentioned, we have a lot of it today. I first wanted to take a quick moment to introduce you to the individuals you'll be hearing from today. My name is Kevin Young. I'm a partner at the law firm of Seyfarth Shaw. I work in our Atlanta office in the Labor and Employment Department. Most of my practice is focused on wage and hour litigation and counseling, and I've spent probably the past 5 years or so focusing heavily on predictive scheduling and fair work week laws like this one, laws that have really swept the country from New York to Seattle, San Francisco, Chicago, Philadelphia, really all over the place. It's been a big focus of my practice. I'm joined today by two of my colleagues here at Seyfarth, Kyle Peterson and Sarah Fowler. Kyle and Sarah are both part of our Labor and Employment Department and our Chicago office. Kyle's a partner in our Chicago office. She, like me, focuses a lot of her practice on wage and hour litigation and counseling. I've known and worked with Kyle for quite a long time. She's a fantastic attorney and counselor and has a really good grip on not just what these laws require, but also on practical considerations in promoting compliance with these laws. We're also joined by Sarah Fowler, who's also part of our Labor and Employment Department, works in our Chicago office. Sarah has really carved out a name for herself by focusing on fair work week and predictive scheduling laws like the one that we're going to see take effect in Chicago in just about a week's time. So we're thrilled to have Kyle and Sarah joining us today. We're also really excited to partner with our friends at Deputy for this presentation. For anyone who doesn't know, Deputy's scheduling software is at the forefront of helping employers to comply with fair work week laws. Deputy has in-house employment lawyers like the one you'll hear from today who regularly consult with local and state government stakeholders, with leading law firms, and with business owners to help ensure that their software is up to date and as tailored as possible for helping to promote compliance with these laws. From everything from creating profitable and accurate schedules to maintaining documentation to evidence compliance years down the line. We're joined today from Deputy by Krista Hardwick. Krista is legal counsel at Deputy. She was a practicing employment lawyer until about a year ago. I might be a little bit off on the date, and has since joined Deputy's team in-house. As you'll hear today, Krista is a wealth of knowledge on fair work week and predictive scheduling laws. She's also obviously a great ambassador for the Deputy product, which she'll be able to show you a little bit of at the end of the presentation. If we go to the next slide. So just a very brief overview before I hand this over of what we'll be covering today. We'll start by me turning this over to Sarah Fowler to provide a detailed, or at least a robust overview of what this new Chicago ordinance is going to require starting July 1st. Sarah will be able to walk through the nooks and crannies of the law and what it means. We'll then turn it to Kyle Peterson, also part of Seyfarth Shaw, to talk first about what Chicago has said, what guidance it's provided to employers pertaining to COVID-19, specifically pertaining to schedule changes that are induced or a result of COVID-19. Kyle will also cover best practices for promoting compliance with these laws. From there, we'll turn it to Krista Hardwick, Deputy, who's going to provide an overview of the solution the deputy can facilitate to promote compliance with this law. We'll also have time for Q&A, and just a quick note before I turn it to Sarah on this. You'll see a Q&A box in the next to the video, next to the slides. You can use that Q&A section to submit questions to us. We'll do our best to get to as many as we can. We'll do so after the hour mark. So certainly if you have a question, feel free to shoot it over to us. We'll do our best to get to it. If we can't get to it, we'll follow up with you afterwards. Certainly we understand that some folks will have to leave at the hour mark, and that's more than fine, obviously. But if you do have a question, we can get to it. We'll do it after the hour mark. So with that, I'm going to turn it over to Sarah Fowler to start with an overview of this new Chicago law.
Thanks, Kevin. And thank you all for joining us today. At long last, we are nearly here with the implementation of Chicago's Fair Workweek law. I know many of you have joined Seyfarth for our breakfast briefings over the past couple of years where we've talked about previewing this law, and it feels strange to say that we're finally here. As Kevin previewed, we are joining 6 other jurisdictions that have currently enacted predictable scheduling and Fair Workweek laws. For those of you who may be familiar with these from other places, usually they're affecting our retail, restaurant, hospitality industries, but because we're Chicago and we don't do things by halves, we've expanded this to a host of other industries that have not yet had the pleasure of dealing with predictable scheduling laws before. And so I know many of you on the line have been thinking hard about how we can be compliant with this new ordinance. And we are going to talk about that today. So this is the overview of the basic landscape of the Chicago Fair Workweek ordinance that we're going to touch upon today. As you can see, there's a lot of different components of this law. So let's dive in. Are you an employer is the first thing you need to think about. For some of you, that is a really easy, straightforward question, but frankly, for others, it can be a rather complicated proposition. You need to meet 3 requirements. You have to have 100 or more employees globally, but 50 of those need to be considered covered employees. We'll talk about that definition again in a minute, but essentially, if you only have 25 employees working in Chicago, you're not going to be a covered employer, no matter how large you are on a global scale. And you need to be primarily engaged in a covered industry. And we have our graphic here on what a covered industry is. The ordinance gives some definition to what these industries mean. They don't really explain what primarily engaged in means, but if you're on the fence about whether or not you're covered, keep in mind that this is an employee-friendly ordinance, and the city is probably going to be looking for ways to find coverage for employees if there is doubt about that. Now, here are some of our more interesting covered industries, not to give short shrift to any of our other ones, but restaurants is a really interesting one to think about because the definition of restaurant really reverses course from the general definition of a covered employer, because to be a restaurant employer in Chicago under this ordinance, you need to have 30 locations globally and 250 employees total at least. And if you have 3 or fewer locations in the city, then you're not considered covered. So we really have to look to a lot of different pieces of the ordinance in some places to understand whether we're even a part of it. Warehouse services is another interesting one. It talks about storage of goods, wares, or commodities for hire or compensation. And then it says in connection with those services, it can include things like distribution or delivery. So if we're just doing delivery, but we're not including the storage of goods, you may not be a covered employer. Now let's talk about who our covered employees are. Now this is a really important piece because as we saw from the covered employer definition, you have to know about who your covered employees are to figure out if you're a covered employer. They really go hand in hand there. And it doesn't cover everyone. You have to be an employee, so we're not counting any independent contractors, but day laborers or temporary laborers can be included if they have a certain service requirement. The employees have to spend a majority of their time physically working in the city. So if you have people who are coming in for a certain percentage of their work, they may not be considered a covered employee. They have to perform a majority of their work in a covered industry. And the key piece of this, and it's unique to Chicago's ordinance, is they have to earn less than or equal to $50,000 a year salaried or $26 per hour. That's a more straightforward way to kind of slice and dice your employees to determine whether or not they're going to be in that covered sect. So if you have 50 employees in the city, you think maybe I'm covered, but if a certain portion of those are high wage earners, maybe you're not in that case. Now, I wanted to make a special note about collective bargaining agreements for those of you who have employees who are subject to those. CBAs that are in effect as of July 1st, when this ordinance goes into effect, are in essence grandfathered in. The city has said it's not going to look at collective bargaining agreements that are dated before the effective date of this ordinance. So the good news is you don't have to change anything or do anything with respect to unionized employees who are subject to a CBA. After, for your future negotiations, you do need to make sure that you're negotiating with this ordinance in mind and including specific waiver provisions for the Fair Workweek ordinance and any subsequent contracts. The language in the Fair Workweek ordinance is very similar to what we've seen in the paid sick leave ordinance in Chicago. So the language that you may have included in any CBAs for that could most likely be used for this one as well. And for the purposes of determining whether you have covered employees, any of these union employees who are covered by a current contract would not be included. So if you have 100 employees in Chicago and 60 of them are in a union, you're only left with 40 covered employees. You wouldn't be considered a covered employer at this time. Now let's talk about some of the substantive requirements of the law. Assuming we're a covered employer, we have a certain number of covered employees. You have to give your covered employees before or when they begin work an initial good faith estimate of their work schedule. It needs to be in writing. That can be an electronic document, but it does need to be some sort of written estimate of the first 90 days of their employment for when they can be expected to work or not to work. It has to include the average weekly hours they can be expected to work. Unlike some of the other predictable scheduling laws, Chicago's ordinance doesn't have a requirement that you need to update that estimate if things change during the course of employment. Certainly a good practice if there is a significant change to someone's estimated work schedule, but it's not required. Employees do have a right to request a modification to that good faith estimate. You don't need to grant their request to modify it, but you do need to respond to them in writing within 3 days of that request. Now, the estimate is just that. It's just an estimate. It's not to say that if you don't have someone working on a Friday in the estimate that you can never schedule them on a Friday, but it does need to be something that's grounded in a good faith belief of when they'd be expected to work. It can't simply be, we can expect you to work anytime, any day of the week for 40 hours. That wouldn't be considered something that's in good faith. The advance notice of work schedules. This is a very commonly spoken about provision. For the first 2 years of this ordinance, we need to post work schedules 10 days before the first day of a new work schedule. And in 2022, that's going to increase to 14 days. Now, you can certainly post schedules further in advance. That's required. If you wanted to go right to 14 days now, there's nothing wrong with that. It's the first day before the first day on a work schedule. And that's a complicated thing to say a little bit, but if your work schedule starts on a Monday and goes for 2 weeks, for example, that 10 days is ticked back from that first Monday of that 2-week work schedule. So it's not 10 days from when an employee actually works their shift. That's something to keep in mind. Now, the ordinance says that you need to post the schedule in a conspicuous place that's accessible and visible to employees. They have said that electronic transmission is okay if that's how you regularly have been transmitting your work schedules to employees via application or other electronic transmission. You don't have to swap over to paper copies right now. Paper copies are certainly fine though. You want to make sure that your date and time stamping any schedules though, so that you prove that you're compliant with the advance notice requirement. And here's the key. For hours that are not included in this initial posted schedule with that 10-day or 14-day advance notice, employees have a right to decline any shifts that were not initially posted. You can't say to me, Sarah, you have to come in and work tomorrow. I need you. I have the right to say that wasn't in the schedule that you initially posted, and I'm sorry, I can't make it in. Predictability pay is the big lead story for ordinances like this, and I'm sure you've all been hearing a lot about it. This is the piece that says if you make changes to an employee's schedule after that 10-day or 14-day notice period, you have to compensate employees for that change subject to certain exceptions. So the basics are that if you're adding hours to an employee's schedule, or you're changing the day or changing the start or stop time of a shift, but you're not changing the total number of hours, those changes require 1 hour of predictability pay, just pay at that employee's regular rate. There is an exception that they put into the rules for this ordinance of a 15-minute grace period. Changes of 15 minutes or less are not going to require predictability pay. Now, if you're canceling or subtracting hours from an employee shift, the amount of predictability pay depends on when you're making that change. If you're canceling or subtracting hours or shifts more than 24 hours in advance, it's still just 1 hour of predictability pay. But if you're making that change to take away hours with less than 24 hours notice, then you're paying half of that employee's regular rate of pay for all of the hours that are subtracted or canceled. And that grace period applies to subtracting hours or subtracting shifts as well. Keep in mind that if you are making schedule changes, you need to then repost that revised or amended work schedule and make sure that the employee is aware of that schedule change, and you need to do it within 24 hours. Now, of course, that's the general rule. There's a lot of exceptions to the general rule, and we do have many applicable exceptions to predictability pay that frankly could make your head spin. We have 10 enumerated exceptions in the Chicago Ordinance to predictability pay, and they are set forth here. Some of them are industry specific. Big picture, the way I like to think about this is, why is the schedule change going into effect? Is this something that the employer is putting forth, that it's an employer initiated schedule change, or is it something that's initiated by the employee? And that's really going to help you decide whether or not you're probably going to have to pay predictability pay in many instances. If it's an employee imposed change, you're not going to have to pay predictability pay. If it's you as an employer making the schedule change, you probably are going to have to pay predictability pay unless there are certain exceptions that are applicable, usually for reasons beyond your control as an employer. So you don't have to pay predictability pay if an employee is calling in sick, if they're coming into work late, if they're requesting vacation. If you need to suspend an employee for disciplinary reasons, so long as you do it in writing, you're not going to have to pay that employee predictability pay while you're suspending them. If an employee wants to swap shifts with another employee, you don't have to pay predictability pay in that instance either. Now, we live in Chicago, so we have exceptions for things like blizzards. If it's Snowmageddon here in Chicago, you're not going to have to pay your entire workforce predictability pay. There are exceptions to that. We are going to talk about the pandemic exception separately in a little bit, but you have utilities failures, if there are strikes or other civil unrest, those are all exceptions under the statute as well. And there are industry specific exceptions for other reasons beyond employers' control that can apply. For manufacturing, for example, if your client cancels an order, that might be a change in production and you might need to cut employee shifts. You're not going to have to pay predictability pay there. For healthcare employers, you don't have to have an employee leave in the middle of a specialized procedure, and they don't have the right to decline to work that additional time if needed for such procedure, or if there are other emergency circumstances. So certainly be mindful of the particular requirements that are in the statute that may be exceptions to this. Another one is the mutually agreed upon schedule change. An employer and employee can agree to change a schedule as long as you have that in writing, and that can be an exception as well. You have to offer work to existing employees before you can hire externally. And this is an interesting requirement that sometimes is left out of the headlines when we're talking about laws like this. When practicable, the offer should be made to part-time employees. And if part-time employees are not interested in the work, you can offer them to temporary or seasonal workers who have worked for you for at least 2 weeks. Now, you only have to offer these positions to those who are qualified to do the job, and you don't have to offer it to any employees if doing so would require you to pay them overtime. But before you go and jump and post externally to bring new employees on, make sure that you're following this requirement to offer the work to your existing folks first, and that you document it to be able to show that you did that. The law also has a right to rest provision. Employees can refuse to work within 10 hours of the end of the prior day's schedule. So think about your closing shifts for an employee one day, and then that employee is scheduled for an opening shift. They can agree to work a shift like that, but you have to pay them a premium rate of 1.25 times the regular rate of pay for all hours during that shift, not just the amount that's in that 10-hour period. And you have to get their consent to work that shift in writing. if they would be entitled to overtime for that shift within that right to rest period, they get that higher overtime rate. So I put two examples on this slide, and the only distinction I wanted to make here is that if someone's working an early morning shift and then working a late shift that day, working on the same day, that's not an exception where you would need to provide that premium pay. It's simply from the end of one day to the start of another to make sure people have that right to have a good rest if they want to. Employees have a right to request a flexible work arrangement under this law. If they want to work part-time, limitations on their availability, you don't have to grant that request, but make sure that we're not retaliating against employees for making that request. There's not a specific requirement to respond to that request in writing, like the initial scheduling estimate, but again, it's a good practice to do so if you can. We have a notice and posting requirement in this law, like many other employment laws. This is an easy way to be compliant, really important that you do it because it's going to be one of the first things the city is going to look at if you find yourself in a situation where we're defending our compliance practices. The notice is available on the city's website. There's a posting requirement. Put it with your other employment posters. If that's physically on site, put it there. If you have electronic posting, like an electronic bulletin board, that's fine as well. You also have to provide notice with the first paycheck after July 1st. For your direct deposit folks, you can do that electronically as well. If you have employees who are not proficient in English, you need to make sure that the poster is also included in that language if the city has posted a poster in that other language, which as of this morning is just Spanish. Record retention is an issue that sometimes we gloss over, but I think it's really critical with laws like this. It's a 3-year record retention requirement. And what it boils down to is this. Anything that you would need to show that you were compliant with these laws, you want to be keeping for 3 years. Because if you can't prove that you were in compliance, that's not a help to you if you're forced to defend your practices here. So that includes your good faith scheduling estimates, your payroll records, all schedule changes, revised schedule changes that are date stamped and time stamped, any employee schedule requests to work, swapping shifts, any of that documentation should be retained and have a system for doing that. We have an anti-retaliation provision, just wanted to make note of that again. So any right that is included in this ordinance, employees are protected against retaliation for exercising those rights, and there are specific fines that can apply toward that. And finally, enforcement. This ordinance is going to be enforced by the city's newly created Office of Labor Standards. They have the power to investigate compliance with this ordinance and issue penalties that can range from $300 to $500 per employee per day of violation. So sure, not paying 1 hour of predictability pay to one employee is not going to be very expensive, but obviously these penalties can add up in the aggregate. There is a private right of action in this ordinance, but there is essentially an exhaustion of administrative remedies requirement. Employees can't just file a lawsuit against you with no notice beforehand. They have to file a complaint with the city. You have an opportunity to respond as an employer. The city will investigate, and only after that investigation is concluded, an employee can bring a private right of action. That private right of action has been suspended until January of 2021 at this time. So those are the basic overviews of the Chicago Fair Workweek Ordinance, and I'm going to turn it over to Kyle now to talk more about some of the practical implications of this law and how to stay compliant. Kyle, you are on mute still.
How about now? Okay, great. Before we dive into sort of next steps of what you need to do to comply with the statute, wanted to just quickly touch on the impact of COVID-19. I find it a little ironic that the city's implementing the predictable scheduling ordinance amidst one of the most unpredictable times facing employers, certainly in my lifetime. But such as it is, we are forging ahead on July 1st. The city did issue a rule last month that says there are some exceptions to the predictability pay, the right to decline and pay for canceling hours and shifts if those were caused by the pandemic. It is not a blanket exemption. You can't just say, okay, going forward until this pandemic's over, our operations are interrupted and we are not going to be subject to this law, it has to be more specific than that, and it's only going to apply to a material change to the employer's operations or operation plan or change in the goods and services that you're operating. So for example, we saw a lot of companies switch from making clothes to making masks, and if that impacts the staffing levels that you'll need, that could be something that triggers this exception. The city has not defined what an operating plan is and has said they do not intend to do that. So I think there is some flexibility there in terms of what that means for your particular organization. I would just, be mindful that, you should have a good faith basis and really be able to explain and connect something that happened as a result of the pandemic and how it had a demonstrable impact on your staffing needs or your operations. Like, for example, here in Chicago, we are switching through the phases of our reopening. And as we move through the phases, the ability of restaurants to operate at different capacities and in different ways are changing. And those kinds of changes and orders that are coming down from the governor and the mayor are the kinds of things that are likely to trigger an exception to the rules for COVID. Next slide, please. So we heard from Sarah all the nitty-gritty rules and requirements, and there are certainly a lot of details. So what's next? What should you be doing to prepare for this? I think one of the first things you should be doing is looking at your policies and practices and what needs to be updated and changed to reflect the new rules here in Chicago. This could be policies or guidelines for when schedules are posted, when employees are notified of what their work schedules are. You want to obviously make sure things are being done to comply with the new timeline that's required, and that there is an appropriate process for documenting the schedules and any schedule changes, and we'll talk about that a little bit more. To the extent you have policies in place or guidelines for when and how employees can agree to change shifts among themselves, you want to take a look at that. Does anything need to be changed or updated there? Perhaps you want to loosen the reins a little bit about when and how employees can do that, but also make sure that there are written documentations and processes in place for your managers to make sure the appropriate records are going to be created and retained for those kinds of shift swaps. For new employees, as Sarah explained, you need to provide this initial good faith estimate of their work schedule. So take a look at your onboarding process and documents and figure out what's the best place to integrate that into the process. It could be something that gets baked into your offer letter or appended on to the wage notices that you should already be providing to new hires in compliance with the Illinois Wage Payment and Collection Act. There's no one right way you have to do it. So, take a look at what your onboarding policies and practices and documentations are and make sure that that gets integrated into whatever that process is. You're also going to want to make sure that your new hires are aware of the policies that impact them as it relates to the predictable scheduling, including how they can make schedule swaps, what's required of them in terms of reducing it to writing, getting approvals, how they can request schedule changes, and other policies that might impact their ability to get on the schedule or come off the schedule. And we should also dust off our document retention policies. As Sarah explained, there's a 3-year retention period for some kinds of documents that may be new for your organization. You might not have retained schedules before. Certainly your pay records and your time records, you should have already retention schedule on those, but you're going to want to make sure that your retention policies and practices now reflect the need to keep schedules, modified schedules, good faith estimates, and all the other kinds of documentation that Sarah talked about and that we'll talk about a little bit more. Employee availability is something that when somebody gets hired, you might have a conversation with them. I'm available generally Mondays through Fridays or on weekends, or these are the kinds of hours I could pick up shifts. And we've been through and are going through a time of tremendous upheaval, and it's quite likely that many of your workers have changes to their availability. And now, as we're looking to comply with this new ordinance, it might be a good time to update your records on when employees are available. This can help you to make better schedules, eliminate the need or minimize the need for schedule changes and schedule swaps if you are working from the most up-to-date information about when your employees are going to be available. Next slide. So I think that one of the keys here is going to be training. As good of policies as you can write and implement, they're only so good if your employees are trained on them and they are being implemented in practice. So we want to make sure that your scheduling managers or whoever's in charge and their managers of scheduling and creating that documentation that you're going to need to prove your compliance understand the mechanics of the ordinance and how they interplay with the company's policies and procedures. I'm not going to run through what all those requirements are, but have indicated here some of the key points of the ordinance that you're going to want to make sure your employees are trained on. And in addition to the documentation, which we are just going to hammer over and over again because it's so important, you want to also make sure that your managers understand and know how to make sure that the predictability pay gets paid. So inevitably, there are going to be times when you're going to have to pay predictability pay, and you need to have managers who understand when that is and what they need to do to ensure that payroll makes those payments and at the appropriate rate. These managers are going to really be your front line of defense in complying with the ordinance, and so it is mission critical to make sure that they are trained on all of the ins and outs and the documentation requirements. In addition to your management team, your payroll team is going to need to be updated on when and how to pay predictability pay. You're probably going to need to have some conversations with third-party payroll providers to make sure that everybody is synced up on the appropriate earnings codes and rates and the process for making sure those get paid. And then finally, on the training piece, I think it's also important to train the covered employees on the key components of the ordinance that impact them. As I mentioned before, they need to understand the permissibility and the process for swapping shifts, that any requests for scheduling changes they make must be reduced to and agreed to in writing. Understanding that if they come in late or leave early without permission, that's not going to trigger a penalty and get them paid. And I also think it's important that they understand they have a right to decline a shift and they have a right to rest. And where I think that's going to become important down the road is when you're trying to prove that an employee voluntarily consented to a shift change such that you could take advantage of an exception. If they don't understand that they have a right to decline, when their manager says, hey, Kyle, can you stay late tonight? You might feel pressured to stay if you don't know that you've got that protection behind you to say, I'm sorry, I can't. Maybe you've got to pick up a child from daycare or what have you. So I think, you know, in the long run, you are going to be well served to make sure your employees understand that down the road. And then finally, as I've mentioned several times, document, document, document. It's really going to be imperative that you can prove you complied with the ordinance. So that's going to require that you create and maintain records in a way that's accessible, that you're going to be able, when the city comes knocking, to pull out those records, to pull out your schedules, your schedule changes, show the timestamp. The Office of Labor Standards has said over and over again in their many webinars on this that they are going to be looking at schedules and timestamps for when modified schedules were issued as sort of their first point of order. So make sure that your systems, whether it's an electronic scheduling system or you're printing out a schedule from the computer, that those are programmed to automatically date stamp those. That's going to be an important frontline defense. And having forms to make it easy for your managers to document their shift changes that are voluntary. The city hasn't published forms, may or may not do that, but certainly there are others out there from other cities that might provide a starting point, and your council can also help with that as well. Before I hand it over to Deputy to take us to the end of the show here, want to read out our CLE code so you can get your CLE credit. It is SS, as in Seyfarth Shaw, 9005. Again, that's SS, Seyfarth Shaw, 9005. Please make a note of that, and you will put it on the CLE form that will be distributed after the program. With that, hand it over to Krista.
Thank you, Kyle and Sarah. Such great information. Hi, everybody. I'm Krista Hardwick. As Kevin mentioned at the beginning, I am legal counsel for Deputy Corporation. I'm just going to wrap everything up as briefly as I can with some tips and tricks on how you can use technology to help with maybe what might be some overwhelming sounding regulatory requirements that we've just heard about. So next slide. What we have here is a picture that my colleague took while he was in a car wash. And this to us is just the perfect kind of visualization of Fair Workweek laws, especially Chicago's, which is a little bit more complicated than some of the others. And, you know, when you think about when you go through a car wash, it's crazy, it's noisy, you cannot see clearly. It makes some children cry, but you know you're going to come out okay on the other end. So the key, as we're going through kind of this car wash of Fair Workweek laws and trying to figure out how to be compliant with all of the various aspects, is to really not be this guy. You can see from looking at the animation which guy I'm talking about. He's the guy in the middle who's just having a lot of fun. Maybe too much. You don't want to stand out. You don't want to stand out to employees as being non-compliant. You don't want to stand out to the investigators and to the auditors. So you want to be one of these people in red here. We're going to try to help you do that. So another visual, I just think visuals are fun. I have young kids and we read Where's Waldo all the time. So I've always got a Where's Waldo visual on my computer if I ever need one, and it fit right in here. You want to be Waldo. I'm not going to show you where he is in here, but again, he's just hidden. He's not standing out. He's probably not going to incur any penalties for any violations because nobody can find him. He's doing such a good job blending in. And last but not least, this is the best animation. You may not even notice, but there's a giant octopus right there, and there he is. Now you can see him, but you got to get real close before you notice him. All right, so just to get into a little bit of statistics, the cool thing about being in-house counsel for a tech company that does employee scheduling and timekeeping software is that I have access to lots of the data around our customers and how they are, who they are, how they are complying, how they're using the software to comply, and who's getting hit with penalties. Obviously, I'm going to keep names secret. You know, I'm not going to tell you so-and-so has been hit with penalties, but I can tell you generally who is doing the scheduling in the businesses is hourly shift worker employees. It's typically a shift supervisor, oftentimes a teenager, someone in their younger 20s, doesn't have a lot of experience, and really is not as intimately familiar with these Fair Work Week regulations as the attorneys you've heard from here today, despite maybe trying to, you know, become familiar, and maybe some of you are on this webinar here today. So what we learned from that is the fact that 61% of these folks are hourly employees who aren't super familiar with the law. In looking at our statistics of the users of our software, in Fair Work Week jurisdictions that have these laws in place, the general rate of shifts that incur predictability pay is 6%. 6% is just the general rate of shifts. Oh, we're going backwards there. One more. 6% of schedules in general incur predictability pay. And that's data we've received from various cities and regulatory bodies in Fair Work Week jurisdictions around the country. Now, of the people who actually use a technology solution, and Deputy in particular, because that's what I have access to knowing the statistics about, only 1% of shifts that are scheduled with a technology solution incur predictability pay. So that's a really significant drop in terms of the amount of penalties that you can see, and why technology just right off the bat can help save you money. Next slide. So Deputy can help you comply with all of the requirements that Sarah and Kyle were just talking about. I'm going to go into quick detail on each one and how it can help you. It can also do a lot more than just Fair Work Week. So whether you're using Deputy or some other technology solution, or if you're not and you're interested, this here in front of you is just a list of some of the compliance rules and regulations that technology can help you with, and it takes a lot of the burden off of your hourly shift workers who are doing your actual scheduling. So what we did is we have met with several investigators from various departments of labor, offices of labor standards, and other agencies around the country who have Fair Work Week regulations. And we just sat down with them in person, and we've talked to them kind of about what their day-to-day is like and what they're looking for when they go in to audit somebody for Fair Work Week violations or Fair Work Week compliance. And what we have found consistently across the board in all of the jurisdictions is that these investigators are working so hard. Typically, the agencies are understaffed. And so these investigators are really focused on finding the gross offenders, the big offenders, the folks that are just blatantly disregarding the regulations. Oh, that's okay, Sarah. Sarah just really likes Where's Waldo, and she wants to keep going back to that one. So anyway, they also have a wide amount of discretion in some of the fines that they're going to assess. So even as Sarah mentioned, I think the rate was $300 to $500 per violation. So that's a $200 range. And so you want to be sure that you're showing really good faith, that you're trying to comply with these regulations, so that hopefully that investigator won't pick you out in the first place because you're not a gross offender. And if they do get you for something, hopefully that you're going to show that by your good faith efforts to comply, they'll assess a fine on the low end of the scale. This also came out of meetings with investigators and regulators. Actually, this one was from New York City when their Fair Work Week law went into effect. And we asked them to kind of draw us a visual of what is in their minds the most important aspects of this law to comply with, because as you've heard, there are many aspects. And so there at the bottom, have an employment manual, policies, share it with your employees and get them to sign that they have received it and that they understand it. That's just basic stuff that they're looking for every employer to have when they go in for an audit. Up above that, on the Fair Work Week side, post the poster. Sarah hit on that. That's number one. You've got to have that poster on the wall. And then after that, we kind of go in order of what's most important to these auditors. The good faith estimate, interestingly, was top of mind for them when they're auditing. They want to see that you're providing that good faith estimate of what the schedule is going to look like to your new hires on or before their first day of work. And that includes all the requirements that are required by the law. And then I'm not going to read all of these to you. You'll have access to the slides after the program and you can kind of look at it at your leisure. But again, you want to be giving people advance notice of schedules. You want to get consent if you're going to change the schedule after that notice period. And then you're going to want to be complying with that access to hours requirement, where you need to offer open shifts to folks who are part-timers to try to get more full-time positions created. We can skip over this. That's just an example of what posters can look like. So these are the 5 very large categories of Fair Workweek law that Deputy has now programmed into the Deputy app. And I didn't mention at the beginning, Deputy is an app literally that your employees will download onto their mobile devices, or that you will download onto an iPad or a desktop computer that will be in the workplace. And so within that app, we can help you with these 5 major categories of Chicago's Fair Workweek law. And so on the next slide, we'll talk about here how we can do good faith estimate. So as Sarah mentioned, good faith estimate is your kind of estimate you give your new hires of what your schedule is going to look like for the first 90 days of employment. And in Deputy, that can be done electronically in what we call our newsfeed feature, which is kind of like I don't know, for this old people on the webinar that have Facebook, it's like your Facebook wall, essentially. So you can post messages to your employees in there. They can respond. They can post messages to each other. So you will create your good faith estimate, hit send. It'll go out to the employee. And then in the app itself, they can electronically confirm that they've received it. So you have that written electronic documentation of when it was sent. You have a copy of it, and you have confirmation that they received it. And also for those of you that really want to have a paper copy of the good faith estimate, you can take a picture of that and then scan a copy into the app and then send that on to the employee in an attachment format. Advance notice of schedules, as Sarah mentioned, right now we need to be posting schedules in Chicago 10 days in advance of when the schedule begins. That'll eventually go up to 14 days. And so what you can do then is you can create and post your schedules electronically within Deputy or whatever your technology solution is that you're using. And then the cool part about it is that you want to try to avoid predictability pay as much as possible. At the same time, you're going to have schedule changes. It's just part of doing business. People are going to get sick. People are going to not show up. People are going to want to change schedules after that notice period. So the neat thing about an electronic technology solution is that employees can then go into the app and they can offer their shifts to other employees. You don't even need to be involved as the employer unless you want to be. And those employees can trade shifts. They can offer their shifts up to other employees to claim, and it's all done within the app itself. And you have that electronic record that it was employee initiated changes, that it was the employees who wanted to swap shifts. It was the employee who offered up their shift to someone else. And so predictability pay isn't due in those cases. You can also put parameters around who would be eligible to claim an open shift, or which employees can swap with which employees, depending on qualifications or availability, or just who you want in those shifts. So that can all be pre-programmed into the technology. So you do maintain control around what your schedule will look like without incurring that predictability pay. This is just a picture of we call it the kiosk in Deputy. It's that electronic screen you're going to have in your workplace that will show up on the screen in the workplace. It'll show the schedule, and it will also show up as soon as you publish your schedule. Will also go out electronically to each employee's mobile device to view on their phones. So predictability pay is, again, the big topic that we've been talking a lot about today. When you're using a technology solution that is customized to Chicago Fair Workweek or any other Fair Workweek law that you might be needing to comply with, the technology can detect when a schedule change is made that should trigger predictability pay. So if you go into deputy and you change the schedule after that 10-day notice period, it's going to detect that it was manager initiated if the manager goes in and changes it. Or you can also have it so that it will pop up with an attestation question saying, I detected this schedule change. Was this manager initiated or was this employee requested? And the answer to that question can then trigger whether predictability pay will be applied to that employee's timesheet. Similarly, if an employee clocks out early or late, or clocks in early or late for a shift, that can also trigger predictability pay if it was manager initiated or employer initiated. For example, if I call Bob and I say, Bob, I need you to come in an hour early today. Obviously, that's a schedule change within the 10-day window, and it's employer initiated because I'm telling Bob to come to work early. It wasn't him requesting it. So again, when he clocks in early, deputy will notice, oh, this is not what he was scheduled to work. And it will ask Bob, was this manager requested or are you coming in early due to personal reasons? And based on his answer to that question is whether predictability pay will be added to the timesheet. So you don't need to worry as the employer about figuring out when you owe predictability pay and how much. It's all pre-programmed into the software for you, which is really nice and time saving. So just briefly, a few more slides here. Access to hours is one of the more nuanced and complicated areas of all of these Fair Workweek laws, in my opinion. It's the idea that these regulators and these government agencies who are enacting these laws really want to decrease the amount of part-time positions out there in the hourly shift workforce. And they want to have every employee who wants to be full-time have that ability to be a full-time employee. So what, again, these require is that if you have open shifts to fill, you cannot go out and hire somebody externally to fill them before you offer them internally to your existing part-time employees who are covered by the law. So what that means in deputy is that it's a whole lot simpler to do it in the app than to do it on pen and paper or try to do it in some manual way. You go into the news feed. Again, I talked about at the beginning, that's kind of your method of communicating within the app. And you just type a post. I have these shifts available this many days a week, this many hours. It's temporary or it's permanent, however you want to say it. You put in what the law requires. And then you can send that to selected employees. You can send that to all your employees at that location. You can send it to all your employees in the city if you'd like. It's very customizable by you based on your interpretation of the law. And then you send it out. Those employees get that notification on their mobile devices and they can then claim those shifts or not claim those shifts. And then you award them based on who has responded to the post. So it makes the process pretty simple. And again, importantly, you've got that electronic documentation of when you sent it out, what was included in the access to hours notice, who bid on the shifts, and who they were awarded to. So it's all right there in the app. The right to rest is essentially the clopening ban or the requirement to pay premium pay for clopenings. If you try to schedule an employee for what we call a clopening shift within deputy, which means it was less than 10 hours from the end of the previous day's shift and the start of the next day's shift, you'll get this notification popping up on your window. So it's really nice. You don't have to remember how many hours apart do the shifts need to be. You'll get reminded if you schedule a clopening shift that, oh, this is going to trigger premium pay. And also this employee needs to consent in writing to work this shift. And then you can either choose to proceed with scheduling that shift or you can back up and put somebody else into that shift so that you won't trigger that premium pay. As Kyle and Sarah both noted, document. Lawyers love to say that, and it's really, really true. A lot of these audits and lawsuits are won or lost on the quality of documentation that the employer has. And so I echo that advice. And just again, in deputy, you can capture all of your schedules, all of your schedule changes. They're automatically date and time stamped because they're electronic. Employee consents are automatically captured. predictability payments automatically captured, and you have that in there. It's in the cloud. Should you, in the unfortunate event, be audited, it's really easy to just print all those reports out for the auditors, and there you go, you're off the hook, and you show that you had good faith and you did everything you could to comply simply by implementing a technology solution that is designed to help you comply. I'm going to end with just a brief bit about demand planning. And I think this is really important in the era that we're in right now with the pandemic and the uncertainty going on around COVID. It's harder and harder right now for employers to create accurate schedules that really mirror what their demand is going to be at any given time. And as we all know, it's really uncertain as to what how many customers we're going to have at any given time, or what the demand for business is going to be. We don't know who's quarantining. We don't know who's going to be coming out into the community, who's going to say, no, thank you, I'll stay home till a vaccine is ready. There's people all across the gamut right now. And so with the technology solution in Deputy, you can create schedules using our demand planning feature that are more accurate, and that will more accurately predict what your demand is going to be at any given time. And the part about that is relevant to Fair Workweek is that the more accurate your schedules are, the less you're going to have to incur predictability pay, because you're not going to have to change them as much. So demand planning is a neat feature. Deputy is not the only software that does it, but I think Deputy does it best. And so it's just something else that's a little added feature to using technology to do your schedule that I think can really help minimize costs. So just in quick summary, you want to have a written compliance program. You want to have policies in place regarding Fair Workweek. You want to train your frontline managers, your schedulers especially, and all your staff on the wage and hour laws, and in particular the Fair Workweek requirements, just because they're so new and most folks are not going to be familiar with those. And then when you're creating your schedules and changing your schedules and doing predictability pay and all of these things, you want to think like an auditor. You want to think like an investigator. You want to really try to have good faith, avoid standing out, and just be where's Waldo.
Awesome. Krista, thank you so much. Kyle and Sarah, thank you as well. We promised to spend some time afterwards going through a few questions and answers, or questions and providing answers. And we'll do that now. I think we've got maybe 3 or 4 questions we'll get to. You may have also seen neither myself nor anyone else who had their heads down when they weren't speaking was being rude. We were actually typing answers to questions, and so if you asked a question, there's a chance that if you look in your chat window, we may have responded to you directly. So make sure you check that as well. I have a few questions I'll key up, and I think a lot of them will go to Sarah, just given that they go to more the nuts and bolts of this new law, which is what Sarah covered. One thing I wanted to note up front, a question that came in quite a few times, is trying to get under the hood or peek underneath the hood of the coverage requirement, where Sarah had mentioned that if you have 3 locations or fewer, you can fall into an exception. As Sarah mentioned, that exception is specific to the restaurant industry. So other industries that have maybe only 1 location or 2 locations in Chicago wouldn't be saved from coverage by this new law by virtue of the fact that they don't have enough locations. The 3 location exception is specific to the restaurant industry. And beyond that, one point that I wanted to highlight, there's a little bit of confusion, I think, in the way that the law is written. I think I'm probably violating cardinal rule number 1 or 2 by reading law to you all in the context of a webinar. You're not supposed to do it, but just so you know what it says, what the ordinance says on the restaurant exception is it says the term restaurant doesn't include businesses limited to 3 or fewer locations in the city that are owned by 1 employer and operating under a sole franchise. That's led to some confusion about, well, what if we're a restaurant, what if we're a restaurant with at least 30 locations across the country, at least 250 employees in the aggregate, and we have 1 location in Chicago, but it's not a franchise. So in other words, does this three location exception apply to the whole restaurant industry, or is it only for franchises? Certainly the conservative view would be to say that if your 1 or 2 locations aren't part of a franchise model, that you should assume you're covered, that this 3 location exception is limited to franchised restaurants. But it's an area that hopefully we'll get more guidance on as we move forward. Beyond that, turning to a couple of the questions that we got, Sarah, I'll start with you. That this is a question that goes more to coverage of employees and what coverage of employees actually means. So the question is, we have a situation where not all employees are covered. So some employees might earn 25 bucks an hour and therefore they're covered, and some might earn 27 bucks an hour and therefore they're not. The question is, are we required to offer extra shifts to the covered employee before they're offered to the employee who's not covered, to the employee who's earning $27, $28, $29 an hour?
Yeah, you do have to make the distinction because the ordinance says that you have to offer shifts to existing covered employees. So take a look at those wages, and if they're earning $27 an hour, yeah, I would offer it first to those who are covered under the ordinance.
Okay. And John's going to keep coming back to you on some of these questions. So another question we got that I thought would be helpful to put out there for the audience, and I'll add one note to this also. There was a question, well, for exempt employees who are covered, can we just have a permanent schedule? And before I turn that question to you, one thing I wanted to emphasize, I know you mentioned, is that while this law is, to me, a bit peculiar in the sense that it applies to a salaried employee who's not earning more than 50, you'll see other laws that aren't written quite that way, that they're really focused more on hourly non-exempt employees. What the Chicago ordinance does say is that if it's a self-scheduler, that they're not covered. It's important to think, though, and to understand what a self-scheduler means. The way the ordinance is written, just so for everyone's edification, is it's essentially someone who makes their own schedule without pre-approval. So if it's a store manager or some sort of retail manager, for example, who's making his or her own schedule but has to run it by the DM or by an RM, you're going to have trouble saying, well, they're not covered because they're a self-scheduler. If, on the other hand, that retail manager is the master of her ship, she can make her schedule, change it, whatever she wants to do, then you'd have a good argument that they're not covered. But turning to the question, for an exempt employee, say earning $49K a year who's not a self-scheduler, so they're covered, can you just have one schedule, you put it out there, and just never revisit it, never republish it?
Yeah, they don't make a distinction. And I think there's even some guidance in one of the FAQs that whether you're exempt or non-exempt is not part of the calculation for the city that they'll take into consideration. So if you're a covered employee, even if you are an exempt employee, you need to follow the requirements of the statute. Now, maybe that person's schedule never changes and you're just giving them the same schedule week after week, but you still have to comply with the requirements of the ordinance, even though you're going through the same thing every single week with them. Hopefully that clarifies things.
Good stuff. And there's one more question I'm looking for. It has to do with on-call situations. And just give me 1 second. I want to make sure I don't butcher it. So bear with me one moment while I flip to it. And Sarah, if you have it in front of you, you can feel free just to read it yourself also.
Let me see here. We can get to it first.
That's all right. Sorry, everybody. Give us 1 second.
Take the question.
Wait, if there's a way to do an on-call shift without paying 50% of the predictability pay for that shift, if you don't call the employee in, and as a corollary to that, can you maintain an on-call list of employees who would voluntarily pick up a shift? So I would look at this in 2 pieces. So if you schedule someone for an on-call shift and do not call them for that shift, then yes, I think you do need to pay them predictability pay the way the ordinance is written. If you have a list of people that you then want to call and say, hey, I have these openings, would anyone like to come in? Does anyone want to pick these up? The employee raises their hand and says, yes, I would like to volunteer for that shift. Then I think that would be an exception to predictability pay if you have the written requirements as part of that, because the employee is asking to work and is picking up that shift. But if you're telling the employee, you need to set aside time and make sure that you are available to come in if we call you. So you have to make sure that your childcare arrangements are scheduled, that you're not scheduling anything else during that time. That's really part of the spirit of these predictability pay laws and why you would need to pay predictability pay in that instance.
Okay. We have a few other questions that are pretty specific that we tried to get to where we could through the chat. I think one point that bears reiteration that Krista made, I think, very nicely in going through the deputy portion. There were a lot of questions about, well, showing or determining whether a given schedule change fits within an exception. And certainly there's going to be a lot of fact sensitivity on some of these exceptions. For instance, a mutually agreed upon mutually agreed upon change of the schedule. As Sarah mentioned, I think a good rule of thumb is that it should be something that the employee requests, that it's not the manager requesting of the employees, certainly not to a specific employee, perhaps different if it's offered to a group. But a really important point that I don't want to lose sight of, and I think makes sense to reemphasize, is the importance of the documentation. And I realize it's the most, lawyer-sounding thing I could say, focus on the documents. But if you think about it, if you think about facing an investigation 6 months, 9 months, a year, 2 years from now, a manager who says, look, we didn't pay predictability pay in this one instance because it was mutually agreed upon. If you're doing not much more than asking them to remember that or to have some sort of notation they make themselves, that sort of thing, you're putting yourself in a pretty tough spot. So whether it's through deputy or some other system that works for you, certainly I think very highly of deputy, but some system that allows you to maintain the records, not just of what the outcome was, but what happened. Some sort of form that says employee asked and manager approved, or employees agreed to swap, and here's what happened. If you're doing something that's closer to just relying on the memory of the manager or relying upon their shorthand that doesn't necessarily mean anything to anybody else, you're making compliance, or at least your ability to demonstrate compliance a year or 2 years from now, a whole lot tougher. So I think we got through all the questions in the chat. Certainly, please feel free to reach out to any one of us afterwards. We'd be happy to help out however we can. We really appreciate y'all taking the time to join us today. We hope you got something out of it, and we hope we've helped to make your lives a little bit easier come July 1st when this new law takes effect. Thanks a lot.